Good evening, everybody, and thank you for coming tonight. And thank you for taking part in the University of Montana's activities marking Constitution Day. I thought I'd begin by giving a very brief account of how Constitution Day came about. In 2005, Senator Robert Byrd of West Virginia, who recently died, attached an amendment to a measure, to a massive appropriations bill, actually. And the amendment required that on September 17th, the day the Constitution was signed, every federal employee had to receive, quote, educational training and materials about the Constitution. But it also required all schools receiving federal funds, everything from nursery schools up through med schools, and that includes universities, and that includes the University of Montana, had to provide some educational programming for Constitution Day or lose federal funding. So we've been very diligent about providing some sort of educational program for Constitution Day. In general, I don't particularly like the feds telling us what to teach and when to teach it, and I'd prefer to take my constitutional instruction from somebody who was not a member of the Ku Klux Klan, thanks very much. But whatever the provenance of the holiday, the American Constitution certainly is a document worth celebrating and worth contemplating. The great British statesman William Gladstone described the American Constitution as the most wonderful work ever struck off at a given time by the brain and purpose of man. Our Constitution is over 200 years old, making it the oldest written Constitution still in effect. And it's difficult to read the American Constitution without being struck by the extent to which it's an 18th century document. And yet, for all of its 18th century characteristics, it remains relevant and functioning. It's been amended only infrequently, 27 times. And the first 10 amendments were adopted at the time of the Constitution, and 3 more were adopted after a cataclysmic civil war. So it's been rarely adopted, but I think one reason for its longevity is that the Constitution itself is adaptable. It provides for its own amendment, although it doesn't make it easy to do so. And more important, it's little more than a statement of general principles. It's a document of less than 8,000 words. It was never intended to be more than a general outline. Had it been too detailed, had it tried to cover all possible contingencies, it would not still be in effect. How else could a written document continue to form the basis of government for a country that began as 13 states huddled on the East Coast and expanded to a nation that spanned a continent? So even if some may have objections to the feds telling us what and when to teach, the Constitution is worth thinking about. I'd like to take a moment at this point to thank the Provost and his office for all of their assistance. They provided funding, advertising, staff support, and Lisa Thomas in the Provost office really deserves special notice. I also want to thank Jim Lopatch for suggesting tonight's speaker and for making contact with him. And I want to take a minute or two to introduce our speaker tonight. And we have a very distinguished speaker. Anthony Johnson graduated from Yale University, earned a JD with honors from University of Chicago Law School, and after law school clerked for Judge Sidney Thomas of the U.S. Court of Appeals for the Ninth Circuit. He practiced law with the prestigious New York firm of Cravath, Swaine, and Moore. For those who are lawyers and are used to that system where you start as an associate and after a certain number of years it's either up or out, Cravath is the firm that invented that system, so you can either thank or blame it depending on how things worked out for you.
I was out.
Now, Anthony's the solicitor for the state of Montana, and in that capacity, he represents the state in a wide variety of matters, including constitutional issues. He teaches as an adjunct professor at the law school, where he's taught election law and the regulation of business. He's taught constitutional law at Carroll College, and we really appreciate his willingness to drive over from Helena to speak to us tonight. His topic is constitutional litigation and its limits, so please join me in giving a warm welcome to Anthony Johnson.
Thank you, Mike, and thank you, Jim, for making the contact. You've already been extremely generous in welcoming me here on the other side of the divide. And thank you for sharing this event with us. As someone who appears before judges often, I'm used to being cut off for questions, and I'd actually encourage that. I hope that I'm not going to spend any more than half of the allotted time actually talking about Constitution Day and constitutional litigation, and that we can spend the balance of the time in dialogue, because that's the way, as those of us who've gone to law school, that it's a good way to learn the law, but it's also really the best way to heed the spirit of the Constitution, is to have a conversation about it rather than simply learn about what the cases say. And that ties into what I'm going to talk about today. What the cases say, of course, is the product of constitutional litigation. But that's nowhere near all of what the Constitution means to us as a nation. I'll start out by trying to figure out, well, what does Constitution Day mean to us as a nation, other than its implications for the funding here at the university. Like any lawyer given an assignment, I began mine by consulting the relevant law. Federal statute, Title 36, Subtitle 1, Part A, Chapter 1, Section 106. There's a almost alphabetical list of national holidays there, which is amazing because the U.S. Code and Congress don't alphabetize much. They try to make things a little harder to find. But right there between Child Health Day and Columbus Day is Constitution Day and Citizenship Day. It is to commemorate the formation and signing on September 17, 1787 of the Constitution, and recognize all who, by coming of age or by naturalization, I'm not sure what the constitutional basis for the first of those is, but or by naturalization, have become citizens. We'll talk about the citizenship part a little later. I think it is interesting that this is not just Constitution Day, it's Constitution Day and Citizenship Day. Should also note, yes, the Constitution was formed and signed on Constitution Day, but it didn't mean anything. It didn't mean anything until we, the people, such as they were, white, usually landholders, meeting in convention in the various 13 states, ratified the Constitution. So the Constitution Day really is just kind of the beginning of the process. They gave us this great document, but it was only a plan, and it didn't mean anything until we, the people, decided to agree to it. We, the people, with very important caveats, obviously, in late 18th century America. So now, constitutional litigation. All litigation is constitutional litigation. Litigation is carrying on a legal dispute through a judicial process. If you're litigating in federal courts, you're litigating under the judicial power of the United States, provided in Article 3. If you're litigating in state courts, you're litigating subject to the Supremacy Clause, the supreme law of the land, that the Constitution and federal laws are of Article 6. So everything we do in courts is determined by the Constitution. But I'd like to focus on a subset of those cases. A very small subset of the cases, by far the small minority of the federal and state court docket, and even a relatively small minority of the U.S. Supreme Court docket. And those are cases that raise a question that has been debated since even before the Constitution. They're cases in which someone comes to court asking for that court to find a law passed by the people's representatives unconstitutional. These are cases where the power of judicial review is invoked. And as I said, that is a very small minority of the cases out there. The vast majority of the operations of our government under the Constitution don't involve this kind of constitutional litigation at all. And I think in some ways that's a tribute that most of the work under the Constitution goes by quietly, and that we as a nation really don't fight over much of the Constitution, except in these very few cases dealing with judicial review. I want to focus on that, I guess, for a few reasons. First of all, it's what I know. That's what I do, constitutional litigation. I've been on one side or the other of constitutional challenges for the past 10 years, or almost all of my legal career. And in my current job, it's what I do. I help the state answer these sorts of constitutional questions that these claims present. Does a prohibition on corporations spending in elections violate the freedom of speech? Do homicide laws unjustifiably infringe on the individual's right to privacy under our state constitution as applied to terminally ill patients who seek a physician's assistance in death? Can the state or the people ban a certain kind of gold mining using cyanide without compensating the gold mines who can no longer mine subject to that law? Those are questions that I've worked on. Those are questions that have been presented in Montana. Some of them are questions I'm still working on. Those are the sorts of questions that it's my job with other lawyers in the Attorney General's office to show up to court and answer and be accountable for those questions. Does that violate the Constitution? Well, it's our job to show up and defend the laws, generally, if they're defensible. So that's one thing. It's what I know, and I hope we can talk more about that. The second thing is that the Supreme Court, the United States Supreme Court, which is responsible for most of what we know as the scope of judicial review, they're the ones who define, both through the substance of their decisions as well as through exercising the power of review that they have. They pick about 1 out of 100 cases that people ask them to take. They're the ones who define the big constitutional cases we see. If there's a big constitutional case and they're not interested in hearing it, well, it might bubble along in the lower courts, but it's not going to come to a head at the U.S. Supreme Court. That court's changed. Almost half of its membership has changed since 2005. And so that sort of change, because they are human, because they were put there for a reason by presidents, because they have different beliefs than their predecessors, will result in a change in the judicial review. We will see what sorts of questions they are interested in and then how they decide those questions. And lastly, and I think most importantly, the Constitution itself has become more of an issue in our politics than it has for a while. Now, there are times where constitutional issues have been raised, where elections will be decided by the right to an abortion, or certain free speech rights, or the conduct of war. They might be decided, but we've heard a lot now of just the Constitution. You should vote for me, you should vote the Constitution. And I am the candidate who stands for the Constitution. That's happened on both sides of the political spectrum. Our president is a former constitutional law professor. His most vocal opponents are the Tea Party movement, is a group of loosely organized people, but they are all organized around the principle of protecting the Constitution. So the Constitution comes up quite a bit recently. And as a result of these cross-currents, we see, lo and behold, constitutional litigation even. We see, the U.S. government, federal administration, sues Arizona over its immigration law, a constitutional case about a state's power to regulate immigration. Various states and some attorneys general sue the federal government over whether the health care reform law is constitutional. These are the sorts of cross-currents that are at play now, where, as Tocqueville said in the past, that any great political question eventually becomes a judicial question. We're seeing that happening today, where people are very litigious and happy to make constitutional claims, both in political discourse and in constitutional litigation. The only thing they have in common, of course, is a faith in the power of judicial review, the power to ask a court to invalidate, strike down laws that we or elected representatives have enacted. And so that power, we're going to be seeing that invoked, I think, in new ways, certainly in future years. And so I think it's worth discussing how that power works, where the rubber meets the road, really, in constitutional litigation in the courtroom. So, how does it work? How do lawyers and courts address the difficult questions when someone comes in and claims that a democratically elected law conflicts with the Constitution and therefore must be invalid? Laws that were enacted today or in recent years, that they conflict with something that was signed 223 years ago tomorrow. And my argument, and it's an explanatory one, it's a descriptive one, it's not a normative one, is that constitutional litigation is really a practical process through which we give reasons to each other. When I show up in court to defend a state law that we as Montanans have passed through our democratic branches, I have to give reasons. When the person who's challenging the law comes in, that person has to give reasons as to why it's constitutional or not. And when the court decides it, they have to give reasons. Now, you might think that constitutional litigation is about rights, and it is, but as I hope to show you, it is at least as much about reasons as it is about the rights that we see in the Constitution. The rights stay the same, I think we'll see, but the reasons change, and the reasons are what make up constitutional law and form the constitutional conversation that we're having today, both in and out of the courtroom. And I want to talk a little bit about not just constitutional litigation then, but its limits. How important what happens out of the courtroom is to what the Constitution means to us. We, the people, may not agree with the reasons the court gives after constitutional litigation. We might not agree with what the courts say the Constitution means. We might think the courts are getting the rights wrong, in other words. But history shows, and please chime in to correct me if I'm wrong, Professor Mayer, but that courts don't have the last word. I think we all think that courts have the last word. Courts sometimes say they have the last word on what the Constitution means, but they don't. We have the last word, and that makes the discussion we're having about the Constitution and the Constitution in politics more important, because the discussions that we're having outside of the courtrooms will eventually form the substance of constitutional law. And I'll talk a little bit about how that works. If we don't like what the courts do, we present new reasons. Maybe the courts change. If the courts don't change, we change the courts. If they still don't change, we change the Constitution. This is played out more often than I think we acknowledge in the history of American constitutional law. So it's not the court's reasons that matter most to the constitutional law in the long run. They matter. As a lawyer, they matter. Just for the record, for judges who, yeah, absolutely, the court, what the courts say matter. That's my stock and trade. I can't cite what I think the Constitution means or what other people think the Constitution means or political candidates think the Constitution means. I have to cite what courts say the Constitution means. But over the long run, they don't matter as much as the reasons we give for what the Constitution means. So, to be more specific, what does it mean that constitutional litigation is about giving reasons as much as it is about citing rights, pointing out rights, standing on rights? Well, let's take an example. Let's assume the law says that a plaintiff cannot go to a public school. And she complains, and she gives a right. She has a right to equal protection of the laws under the 14th Amendment. That's the right. Does that answer the question? No. We need to know more about the reasons. We need to know more about the reasons that the state gives, what reasons she has to assert the right. And so the court will ask, what reason does the state have for not allowing the plaintiff to come into this public school? And it is the reason that will determine whether or not that law that keeps the plaintiff out of the school is constitutional or not. So we can start with what is today an easy case, but has not always been an easy case, and actually today may not be as easy a case as we think. Let's say the state says you cannot come into the school because of your race. Well, if that's all, as we all know, that's not good enough. It's not a good enough reason. The state loses. But wait, the state says, I know it's the same right, but I have more, there's more to that reason. She cannot attend the public school because it's part of an affirmative action plan that's intended to remedy historic discrimination. In fact, at one point may have been ordered by a court. Well, that reason may win. The state wins. What if they say, well, and this is still changing, and this reason is not as strong as it has been in the past, but we wanted to increase the diversity of our student population. And we're an institution of higher education. And to make sure I get it, it's become a narrower rule in recent years, and we don't use any quotas, and it's necessary to maintain a critical mass of minority enrollment. If you meet all those, if that's a reason, that's good enough. The state's law passes. Just race? No. Race plus reasons? Well, that might be okay. Well, what if the law kept out our plaintiff based on her religion? Well, again, just like race, if that's all, no. In fact, not even if you can show and have shown that it might convey some educational benefit to the students. That these students will learn better together if it's a small religious sect, and they'll learn better in a community. No, you can't do that. But what if the state says, well, yes, it's because of her religion, but it's because she wants to take state money and attend a seminary, and we don't want to get tangled up in that. Well, that is good enough. Same right, different reasons, different results. What about gender? Well, unclear. Unclear for a longer time, actually, than race. If the state wants to keep her out, what's the reason? Well, we have a long tradition of a male academy, and we think that's better for our educational system. That's not good enough. Waite says the state, well, we also have another gender segregated one for girls and women, and it is targeted to certain educational benefits. Well, maybe, but again, it depends on the reason. And if you're going to show that there are benefits, those reasons have to come with some real world evidence. You can stare at equal protection all you want, but it's not going to answer the question of whether the reasons you give are good enough. You need to come to court, and Justice Ginsburg was very clear on this in the Virginia Military Institute case. She might buy that argument, but you've really got to show that there's real benefit. It's about reasons, it's about reality, it's not about the right. The right gets you into court, it's not going to win anything for you. Well, what about if she was excluded because she was an immigrant and not naturalized? Well, in almost every instance there, the courts have said no. That's never a proper instance. Well, but what if they're not going to vote? And the purpose of a public education system is to create good citizens. And if they're not citizens, then we shouldn't have to expend tax dollars on it. No, that's never a good enough reason. That actually is one of the few areas it's actually pretty clear. It's up there with race and religion and perhaps gender. What about if she was poor? Because of where she was born, she was in a school district that did not have the resources to provide an education equal to that of her neighbors in the next school district. Well, tell us more, say the court. That's pretty much it. We're a state. We believe in local control. We believe that the local school districts should be able to raise taxes and fund their schools on their own, up above a basic level of education that the state provides. That's it. Well, that's a good enough reason, actually, says the Supreme Court. And the interesting thing, and this is the first of maybe examples of where what the court says isn't the last word, is that that's a matter of the U.S. Constitution. Montana's Constitution, actually right about at the same time the U.S. Supreme Court was saying that poverty is not a violation. There's no reason the state really needs to give for having differences in educational opportunity due to income. The state constitution created a constitutional right to equal educational opportunity. And that means something. And the state has gone into court and given the same reason that San Antonio gave to the U.S. Supreme Court, and it didn't cut it. That wasn't a good enough reason. Go back, equalize funding. So there, the response really was that we have this federal right, but it's not really good enough. So let's bump it up a little bit. Let's try to provide some equality at the state level. Let's embody our reasons in something more specific, our aspirations into a more specific right. But at the federal level, under the Constitution we're celebrating today, no. It's a good enough reason that you have a tax policy and things are going to end up differently across districts. All of these cases, of course, involve discrimination under the Equal Protection Clause, but this reason-giving process, the fact that you have a right, equal protection, you can call it due process, you can call it free speech, you can call it free exercise, that is a process of reason-giving that plays out for all of them. You can stare at the words all you want. They're not going to tell you whether you win or lose until someone starts giving reasons that this is my right to free speech and I should assert it because as a corporation or a nonprofit, we need to associate to speak. You need to give reasons. These cases are not won on the basis just of rights. Well, so how does that make any sense? How can our equal protection of the laws protect us so unequally, based not on the right, not on what it says, but on the reasons that lawyers give to courts and then courts give back to us? Well, equal protection, is it the text? No, it protects persons. That doesn't answer the question. We know that at about the same time, Congress was being more specific in other amendments. When it outlawed slavery, it talked about the slaves that were going to benefit from that. When it extended the right to vote, it said, we're doing this on the basis of race, but for the Equal Protection Clause. Persons, just persons. Well, maybe it's the history. And I was talking with, Professor Huff reminded me of a discussion that the same Congress that enacted the 14th Amendment, that enacted equal protection of the laws, also segregated the District of Columbia schools. So that history doesn't tell you much. 30 years later, a generation later, in Plessy versus Ferguson, the court said, separate but equal is good enough. That was the reason the state gave, and that was good enough. I mean, you can look at the right hasn't changed. What does change? Why are we in a world now where that isn't good enough, either in the courts or in our politics? What I think it is experience, this experience of this interplay of reasons given in the court, reasons we give each other outside of the court, and how the real world outside finds its way into the courts. As courts sort through these reasons, they start to learn. The world finds its way into the courtroom. It's not easy for the world to get inside a courtroom, but it has to do it through the witnesses, expert testimony, past cases, documents, the judge's judgment and what the judge, he or she may bring to the bench. But at its best, that constitutional litigation is a process of giving reasons and continuing to give reasons and coming up with new reasons and grounding those reasons in the real world. And courts responding to those reasons differently and changing. The best example of it, I think, is Brown versus Board of Education. The NAACP, which was eventually in this litigation led by Justice Thurgood Marshall, also the United States Solicitor General, brought a series of challenges to separate but equal. Well, here you are, and you have same old equal protection clause that has been there since the 1860s. The problem is that the reason that separate but equal that states have been giving has been good enough. How do you change that? Well, what he realized is that you need to bring some of those reasons that are bubbling around outside. Some of those reasons that said, well, I'll tell you what he did. He started challenging, they started challenging law schools. Law schools, because the state couldn't come up with a reason that we have a separate but equal law school, unlike their primary and secondary schools. Yet they still tried to exclude African American students. And, by the way, that most of the justices would have gone to law school. Many of those law schools were already integrated at the time that those justices went there. And so it was a way of finding, well, maybe here's a better reason. These guys understand law school. They understand the importance of it, the opportunities that they've been given. And so we started with law schools and went law school by law school by law school. Texas finally caught on, tried to start its own law school and said, here, we have a separate law school. That's a good enough reason, right? It was a good enough reason in Plessy. The Equal Protection Clause hasn't changed, separate but equal. And finally, enough of the real world had come in through this process of reason giving that the court said, no, it's not good enough. And that was in 1950. And in 1954, it had been set up so that the court could declare that separate but equal is unconstitutional even in primary and secondary schools, even though that's the way it had been since the Equal Protection Clause had been enacted. And the court, it wasn't rights that it turned on, it wasn't rights that's changed, it was reasons. The court cited psychological studies of children in these schools and the damage that segregation caused. They cited more psychological studies than they cited their own cases. These reasons, the world had finally gotten in and broken through. And that is the process that most constitutional litigation and constitutional change goes through. They wear down, these bad reasons wear down after repeated contact with reality. It's not a smooth process. A decade before Brown versus Board of Education, the Supreme Court upheld the internment of Japanese American citizens. There's a long story. In the 1920s, the court struck down the minimum wage as a violation of due process. In the 1930s, it reversed course. In the 1940s, within 3 years, it upheld and then struck down a law requiring students to salute the flag. It struck down the death penalty in 1972. And then, after I think what most lawyers agree are very minor changes in them, upheld it again in 1976. Struck down, when the court struck down prosecutions of same-sex couples for sodomy in 2005. It was just 17 years after it had clearly upheld them. So it's not a clear or logical process. It's a process based on experience and on the messy interplay of reasons. And you can't look at that and say, well, they're just looking at, it's just the right. They're getting the right wrong, because whichever side you're on, they can't have gotten all of those cases correct. 20 years ago, the court said that states could prohibit corporations from spending in campaigns. This year, they said that the federal government can't. We still say that states can, but that's another story. So how could something that is called constitutional law be so susceptible to change? Well, actually in Citizens United, the court explained. We're stuck with the Constitution. The court understands that reasons change because the rights aren't going to change. Citizens United, the court says, we reject these past cases because they were not well reasoned. Not well reasoned. They were undermined by experience. And in all of these other cases, the courts reached that conclusion. They saw new reasons. The world had changed, perhaps. The facts had changed. The plaintiffs had come in with different stories. And they gave the court new reasons to reach new conclusions. The rights didn't change, but the reasons did. And underlying this all, we should remember, where are these reasons coming from? Well, I mean, they come from the lawyers. I figure out what reasons to give. But they ultimately come from us, all of us, by which I mean you, not lawyers, not judges, people. We elect the lawmakers. We elect the presidents who pick the justices. We elect the justices in Montana. We bring our stories to the courts. We, especially you at the university, translate experience into learning, translate that into reasons we can give to the court, such as footnote 11 of Brown, talking about the damage that segregation does. Those reasons are all generated outside of the courtroom. And constitutional litigation is the process of bringing them in. There are important limitations to that. Most of the Constitution is simply off limits to the court. The court said, we're not interested in hearing claims. We're not interested in hearing whether or not you think that that executively authorized military action is a war or not. Constitutional litigation isn't going to solve that. We're not interested in hearing whether or not you think you've been, your political power has been diminished by gerrymandering. Well, they're not interested yet. They might get interested, but they're not interested now. We can't hear about, we don't want to hear your claims about extraordinary rendition violating due process, because there's a state secrets privilege. We're not going to get into those national security areas. We're not going to get into whether warrantless wiretapping violates our rights against unreasonable searches and seizures. And so there are limits to constitutional litigation, limits that the court itself draws, and limits that are inherent to the nature of the courtroom, of what can and can't get in there. I want to go back to the other day we celebrate today, Citizenship Day. And in Citizenship Day, when you're naturalized, you take an oath. You take an oath to support the Constitution. Those of us who are born here don't necessarily have to take an oath, but that's the same oath that judges, lawyers, our elected officials take. And I think it's worth noting that Congress has put Constitution Day and Citizenship Day together, because I think what they're telling us is the obvious point, is that we all support the Constitution. And this process of reason giving, the fact that the rights don't change but the reasons do, and it's the reasons that make what constitutional law is through this process, means that ultimately what the Constitution is something we have made, not the courts. I think that's what history shows us. It's the history of Brown versus Board of Education, for example. That didn't desegregate schools. As Professor Mayer has written, it's the President, it's the National Guard, it was Congress, through not just direct intervention, but indirect intervention, like the Voting Rights Act, the Civil Rights Acts. The court very rarely in history has its reasons sufficed to make the kind of grand changes that we give it credit for. And that's why I think when we think about Constitution Day, the Constitution Day does not belong to the courts, it belongs to the citizens. And we take the same oath. And I think to be truest to that oath is for us to learn the one thing I think that you should learn from constitutional litigation, not that it takes a long time, that it's expensive, that it's contested, but the one thing that you should take from that, and from, I think, what I take into my life from what I do in the courtroom, is that to be a citizen is to give reasons. And when we discuss the Constitution, when you hear someone say, vote the Constitution, and someone standing on the Constitution, that having that discussion is not to have a discussion about rights. It's to have a discussion about reasons. You can say, I have a First Amendment right to do this. What constitutional litigation teaches us is that that's not an answer. You have to have reasons. You have to say, because we live in a place where this will happen and people have these interests and I'm going to tell you these stories and these are all reasons why you should agree to me that that First Amendment right applies to me in this way. So, as we think about it, and I hope we'll take that oath seriously to support the Constitution, the best way you can do it is to, rather than talking about just rights and ending the conversation with that, as we talk about the Constitution, and we should, in our politics, we should talk to people who disagree with it, disagree with our views on it. We should have that conversation, but as we have that conversation, to support the Constitution is to talk not just about rights, but about reasons. Thanks. I'd be happy to answer questions.
Thank you, Anthony. Very good talk and very clear about a different perspective, your perspective of reasons so we can bring to understand the Constitution. Very Holmesian, I guess the ghost of Holmes was with us tonight. I want you to think about Senator D. O'Connor's opinion in the Casey case, where she passionately argued for stare decisis precedent with respect to Roe v. Wade. And I'm wondering to what degree those questions of legitimacy and role and predictability, consistency in the court are a check on what you're saying or your major theme, or is your major theme, using your major theme to reflect on what O'Connor said, was she saying there just were not good enough reasons given for the change?
I think that's right. So this question of stare decisis, of letting decisions stand, is the other side of it. And I think to the extent that this view of constitutional litigation as giving reasons and testing them, really freewheeling, precedent being only one factor of many out there, is a challenge to stare decisis. And so in the Casey case, the court was asked to overrule Roe versus Wade. But I think actually that is proof of that this is the way that it's actually working. I think you look at that decision, which as you go through it, and there are people here who know much more about it than I do, but essentially what that did was, after an incredibly contentious 2 decades in politics and in law, in some ways harmonized and to the view of those who support more expansive abortion rights, weakened Roe and made it look a lot more like what our politics look like as a national level in terms of the restrictions that can be placed on the exercise of the right that was determined in Roe. So I don't think it was, yes, they said we're all teaming up and standing for stare decisis. But I think, as you said, it was, the reality of it is that they decided that we're looking at these reasons, and actually some of the reasons are good enough for us to weaken Roe. And some of the reasons are strong enough for us to bring it more in harmony with the actual practice of the states. The reasons that the states and people in the political debate had given for why there should be notification periods or any of the other restrictions on Roe versus Wade that Casey upheld. So I think it actually proves the point. Yes, they said stare decisis, but it wouldn't have been stare decisis if they didn't agree with the reasons. And so it's not a coincidence that Casey looks a lot like what the politics of abortion look like if you had to take a poll. And that's not me saying, that's what people who've looked at it have said.
So, I think you make a good point about how social movements and influence how the courts interpret rights. But, and certainly I think there have been times, though, when the court actually stood in the way of social progress in the wake of the Civil War, and for decades after that, the court actually thwarted social progress and equality. But then, as you said, ultimately the court came around to being closer to what society wanted. So you can imagine a person saying, well then, gee, why do we have these courts? Why don't we just rely on the democratic process? So can you talk a little bit about why courts are important?
Well, and this is a debate from the beginning about whether judicial review has a role. And it was clear, you read the Federalist Papers and you read the debates on the Constitution, that they thought that was going to be there, that Marshall got it right when he exercised judicial review, but they didn't exercise it again until Dred Scott. I think the answer that courts are a democratic institution. I mean, rather than thinking about them as majoritarian or counter-majoritarian, they're democratic. They just do their work differently and more slowly and with much more limited knowledge of what the real world is like than the rest of politics does. But they're good at some things, and there are certainly important moments. The truly transformative cases of the court have been, for example, the apportionment cases, where they'd said one person, one vote, or where they have intervened to change the political structure directly rather than just telling the politicians what they can and can't do. So I think that whether that's why we had the court, I'm not sure. But again, this is a descriptive rather than a normative claim. I don't think that you can get away from the fact that the court is very loosely going to track where we the people are. And to the extent that the court gets things wrong that obstruct any one conception of social progress, that's an argument for the court to be more cautious in all of its judicial review rather than more adventuresome. Irma?
I think this is, like Professor Lopatch, a striking reinterpretation to focus on reasons rather than rights, and I think it's optimistic in a good way, optimistic, not in a naive way. But it makes me think about Citizens United, which you noted, and it's something of a challenge to this thesis, because it seems to ground corporate rights so thoroughly in individual rights that it may be difficult to moderate that in terms of reason. I wonder what you see as a moderating force for that.
Well, that is the great counterexample where 80% of Americans right now, and polls, this is never a story of what the polls say. We have to see how people actually behave in response to it. But according to the polls and the State of the Union, it's not a decision that most people like. It is not an instance of the court. It's an instance of the court getting too far out ahead or going too far back, one way or the other, relative to where we the people might think we are. I mean, these are 26 states had these laws. They were enacted at the federal level. I think the story of Citizens United isn't over yet. I think as a case, if you read the main opinion, you see that he gives plenty of reasons. The striking thing about it as a lawyer, as a constitutional litigator, is Citizens United was not a case that arose from constitutional litigation. It was decided on a thin record. Citizens United had injected all of $2,000 into a $1 billion presidential primary. And so I am an optimist about that because to the extent one might disagree with it as being out of step with what the rest of us might think the Constitution means, it is an area where reality will very quickly catch up. And it's also an area where, remember what they're doing. Yes, they're striking down a law. They're saying that corporations can spend. We have not quite seen a quick transformation. Corporations that have actually gotten out there and spent, public corporations, have kind of gotten themselves in trouble. We're not used to that. The court may say it's okay, but we're not. And so there is an aspect of civil society being kind of a brake on any rapid change. Whether 20 years from now we're back to where we were 20 years ago, I don't know. But that is going to be the most interesting case to watch, because unlike many of these other cases, there were lots of reasons there, but there was no constitutional litigation to back it up. The real world really hadn't entered into that. So it will be tested.
Anthony, you speak of these reasons as sort of bubbling up from the public or from public ideas, but legal scholars play a role, and they play a role both in crystallizing those reasons and sometimes even in catalyzing them. I'm thinking of Reich's famous paper on new property and the notion that statutory entitlements should get due process protections. I don't think that was running. No, a lot of people were running around that. It was a big public issue, but it turned out to be hugely important in terms of protecting people who got those entitlements from, I guess I'd call them high-handed bureaucrats. What role do you think
No offense
plays
taken.
in all this?
I think that's true. I guess it's a question of who legal scholars are, both who they're talking to, but I guess really a question of who is listening to them. One of the things that makes me think of are the contested schools of interpretation. So one area that has the kind of most macro level effects are whether or not, and the legal academy, particularly constitutional law scholars, spend a ton of time worrying about or you should be originalist, should you be pragmatic? The justices take time out of their busy schedules to write books on them. Justice Breyer has one coming out. How are we supposed to do this stuff? And that is a debate that can only happen in the legal academy, where they can really think hard about those questions, with the hope that they are somehow informing not just the justices, but the judges. I think it plays less of a role because not every judge co-teaches a philosophy of law class. And that is an amazing thing, but judges have so much to do that I think those ideas are likely to get to them perhaps through their clerks, through lawyers. I mean, I try to read legal scholarship and be a good consumer of it and get it in front of the courts. But to the extent, taking just the schools of interpretation, for example, again, looking at a descriptive level, you're not going to have that impact. There have been two originalists, arguably, in the history of the Supreme Court. It's not, you might look at the lower courts and they're too busy with a much bigger caseload to do that. So these big debates among the legal academy about which is right are important to have. But I'm actually of this school, and it's kind of an evolving school, that it's much more important to have some diversity of justices so that those reasons, really, you make sure that all the reasons get played out. If we had 9 originalists, one reason we don't is because not everyone agrees that those are the right reasons to give. And so I don't think we'll ever have agreement on that. The legal academy affects those who adhere to those schools and is a catalyst for change, but we're not going to see a court ever follow any one professor's ideas, sadly.
I'm a little bit less optimistic about the process of reason, simply because sometimes judges aren't the best situated people to weigh reasons. You cited footnote 11 in Brown. There's some pretty bad social science in there. Kenneth Clark's Dahl test actually showed that a higher percentage of black children who are, first of all, it's too small a sample to mean much of anything, but a higher percentage of black children confronted with the Dahls in New York chose the black doll over the white doll than in the segregated South, which may suggest that the de facto segregation of the North was even more harmful than the de jure segregation of the South. That's not what the way that the judges read that evidence, and they didn't. They clearly didn't seem to understand that. Or in the Durham case, which revised McNaughton, Bazelon's decision was based on some pretty tenuous psychology, which later he and other judges had to back off of. So, I mean, these judges are weighing so many different issues and so many different reasons, many of which, in a technical sense at least, are not really qualified to weigh very well. And so what happens in that process?
Well, I think this goes back actually to the point I was talking about with Tom. It doesn't matter if judges don't get any particular area right as long as there are enough of them who are looking at different reasons that are coming in. And so in Brown, it didn't turn, it shouldn't have turned on what a few psychological studies have shown. It should have turned on a practice that actually Brown had majority support in the country at the time. And this might be an area where, what the courts are doing is, to go back to your question, is they're really bringing outliers back into the broader constitutional mainstream. So Brown, people supported it. The reasons might not have been good there. But again, I would be an optimist because I'd say if that was really wrong, if the decision was wrong, go to Citizens United. If the decision is wrong, well, it will be corrected. If it was right but decided for the wrong reasons, people will find better reasons. And in fact, they did. Congress ended up finding better reasons. The president found better reasons. But I think that, in any one case, as long as the court remains open to it, and as long as the court hasn't decided that only one type of thing counts, whether it's a value of interpretation or it will work itself out. So, yeah, Brown might have been wrong on social science. I don't know, but by the time anyone went back to check, we'd all agreed with the reasons.
Just going back to the civil idea of Constitution, I'm in the paralegal program. You're talking about the Constitution thing. At least for a moment, we all came to the conclusion as to why we have the U.S. federal Constitution when each state has a constitution. What's kind of the importance of the federal one if it's kind of rewritten, expounded upon more in the state one? Is there danger in just abolishing the federal case for morale or our psyches, or is it just kind of like this?
Well, I think that's, yeah. If we were in one of the original 13 colonies rather than in Montana, that would be maybe an easier call. Of course, Montana was created itself by Congress, which was set up by the Constitution. But I think that's a good question because states all had constitutions beforehand. And in fact, state constitutions, this was something that came up in the Second Amendment case about the right to bear arms. States all actually guaranteed rights to bear arms, many of them. And a lot of what the court looked at was what rights the states guaranteed. And one of the responses was, well, why would the U.S. Constitution, if it didn't have anything to add to it, why would they simply be drawing on that? But that's something we look at. States have their own constitutions. I think the answer to that is not in the Bill of Rights. The Bill of Rights, which really was a sampler of states' bills of rights and insisted upon by states and conventions. They said, we're not going to adopt it. The answer is in the Constitution that was signed on Constitution Day, articles, the main body of articles. I'm embarrassed, 1 through 7. That was not a matter of describing certain rights here or there. It was about setting up a nation, a national body that was going to be stronger together than it was apart. And those debates still are with us in debates over the healthcare law, for example. But that is I think that's the answer. The reason we need the Constitution and have that, even though states have very good constitutions that may be more protective of individual rights, we've still decided to be a nation, and we've still agreed that we're going to have a Congress that can tax and spend and regulate interstate commerce and engage in war and have armies and navies. So it's not about the individual rights, it's more about our unity as a nation.
You kept saying that you were just giving a descriptive account of what you see out there. But you didn't disagree with Dean Russell when she said you're an optimist.
Yes.
You're an optimist, you're passing your judgment, aren't you?
Well, I think that I am an optimist because I think that as someone who looks at the court and who oftentimes criticizes the court or hears people criticizing the court, that and hears people talking about the Constitution and hears people criticizing people talking about the Constitution. What do these guys know about the Constitution? We have our constitutional rights here that the Supreme Court has said. I'm an optimist because I view both of those as not being, I don't agree with people who think that that might be dangerous or inappropriate for us to talk about and bring the Constitution into politics more. But if we're going to do that, as I said, it does have to be a conversation. It can't be about, I have a right to this and you can't do that. You have to resort not to the document, but to us, the nation, the reality. And as long as that's happening, I guess I am an optimist about that.
And I'm sure you're familiar with the worry that you inspire us in that, sort of deontological position. That everyone has basic rights, and the courts stand between those rights being inviolable. And what comes and goes, in terms of politics and what people think and what they think is reasonable. Do you think that's you must really disagree with that, right?
Well, dispositionally in my current job, I suppose I'm a bit of a Thayerian, so it says lots of deference. But I guess I'd also say in response to that is I don't think descriptively, again, that that's the way that it works. The court doesn't get too far out in front of or behind we the people for very long. And when it does and when it's bad, we have civil war or civil rights movement. So I don't think that, I just think descriptively it's not been the case that the court can get that far. They're picked by politicians. They have to answer to history. They live in our world. But I think, and as an optimist, I'd look at that and say that those inviolable rights that do protect minorities against the majority in some of the classic cases are rights that we deserve credit for, not just the judges. We've decided to live in a country and have a court that and a society that is able to sustain that at our best. And so we all deserve credit for what the process that the civil rights movement started, for example. It wasn't Brown versus Board of Education, it was all of us.
So you don't disagree with that, you just think we don't have to worry about it?
Well, was it Madison who said that if we, no, it wasn't. It was a 20th century justice who talked about that as long as liberty lies in the hearts of men, we don't need a constitution, and if it dies in the hearts of men, no constitution can save it. I think that's right. I think that is descriptively, as a matter of human nature, right. And as an optimist, I'd say that we, the people, deserve, with some mistakes certainly, we own the court's mistakes, but we also ought to own its triumphs. Michelle.
Anthony, can you address if courts have the ability to be policymakers and amend laws? As you recall from Justice Sotomayor's hearing, she received a lot heckling for saying courts are policymakers. And can you also address the limits that courts have with remedies when they find a law unconstitutional?
Well, on the second point, I think Brown is one of the answers. I think there are other answers too. Is that courts, he is in the earlier years. He is. I'm not a historian, but I think it was Jackson. They have rendered their decision. Now let them enforce it. So that I think is the court does have to be careful. There has to be some craftsmanship, some good lawyering in terms of what remedies it orders, and they have to be realistic remedies. And sometimes they can just say something, as they did in Brown, say it again, as they did in Brown 2. They really meant it, and then just hope, as the story that Professor Mayer tells, that you have the person who is in charge of the National Guard sympathize with it, that you've eventually convinced them. Now, with respect to the decision about policymakers, I think that is descriptively true and should be true with respect to statutes. Statutes, it's more of it's an easier agency problem. A legislator, such as yourself, you pass a law, you can't anticipate all the various circumstances that it might run into, and so we expect that judges who are lawyers will help solve some of those problems, fill in the gaps. And again, there's no one school that's dominant in exactly how you do it, but that was part of the judicial power that was uncontroversial, even before there are many statutes, that there has to be this common law process. But the important thing about that is, unlike constitutional decisions, if you, as the representative that we have elected to represent us and make policy, don't like the direction that the courts are going with policy, you can change it. That's a reason why stare decisis is stronger in legislative interpretation than it is in constitutional interpretation, because the legislature can always come back and change it. Constitutional interpretation, we would worry more when the court gets it wrong, because it's much harder to change. We, the people, have to, it's a little messier. It's all those reversals over time, rather than just asking the Congress to change the law.
Are courts limited to the options of just striking down a law they find unconstitutional, or just striking part of it? Do they have the liberty to add new language?
Well, the U.S. Supreme Court has been, has said that recently that it doesn't. I mean, it's usually tries to be careful with that, but that is again a limit. It gets into these technical questions of severability and can the court strike down some, not others. But that is a basic remedial problem, right? They won't write the law. They might just declare the whole thing unconstitutional, but courts are just, as an institution, going to be clumsy in picking and choosing which parts of a law they think may or may not be constitutional. A much better area for that, would be in the exercise of executive discretion. We see presidents veto statements. They do that. Courts are going to be, it's going to be harder for courts to make those fine distinctions. Well, thank you.
Thank you for coming out, and thanks. Let's give a round of applause. Thank you for a long drive.
Right on. Yeah, thank you. Thank you. It's a pleasure.